think we'll start by me introducing the three of you to everyone. In the middle, we have Monty Levy. She's running for Department N as in Nancy. She's at the 5:30 time slot on our sheets. Then to my right is Vince Ochoa. He's on the 6 o'clock time slot on our sheets. He's the incumbent in Department S as in Sam. And then to Monty's left is Jason, is it pronounced Stoffel? Stoffel, who is also running in Department S as in Sam. So hopefully while you were waiting patiently out front, and we do appreciate your patience, I realize we're running a few minutes late. Hopefully you had an opportunity to review the letter that I had drafted regarding when we're going to release our endorsements. Judging by the blank stares, that's a no.
I read your email.
Yes, this is a separate letter that I just had printed up this morning.
I heard you say to the last room.
Well,
September 22nd.
I guess for everybody, we plan on releasing our endorsements on the week of September 22nd. Next weekend, obviously, is the Labor Day weekend, so we will not be doing interviews. And the weekend of the 13th, the weekend of the 6th, we'll be doing our makeup interviews for individuals who could not be present today. Then, the weekend of the 13th, we're having our annual awards banquet. It's going to be somewhere between a 350 to 400 person event. I know some of you have attended in the past, but we'll be giving out awards to various members of the community, who have contributed to various social causes and things of that nature. You will, obviously, all of you are invited. We do have some extra invitations here, and you can sign up on our website as well. But with all the work that a 400-person banquet entails, we're just not going to have an opportunity to get the endorsements out until the week of the 22nd, plain and simple. In addition to getting out our endorsements to the individuals on the mailing list that you were all sent, we will also be taking out ad space in some Asian periodicals, newspapers, things of that nature. We'll be taking out ads and listing essentially our slate card as to who we're endorsing for all the various races, not only judicial, but also the state assembly, state senate, and also various congressional and county-wide races. Lastly, on October 18th, we're going to be renting, which is the first day of early voting, as I'm sure you all know, we're going to be renting out a portion of the Harbor Palace restaurant, which is up on Spring Mountain, just about a mile and a half east of here. We'll be renting it out for lunch, offering free food, and encouraging people from the community to come out and enjoy the food at Harbor Palace. We will be inviting all the candidates who we endorse to come join us as well. We will give everybody who shows up a slate card, and we will happily encourage them to go participate in the early voting. As luck would have it, there's an early voting site within the Chinatown complex itself, which is literally 105 feet away from the entrance to the Harbor Palace restaurant. So we do our best to get your name out there once we do endorse you for a particular race. In the past, we've had anywhere between an 80 to 90% success rate with our endorsements, and we do want that to continue. But in order for that to continue, we need to have moments like this where the three of you come in and meet with us so we get to know you guys better and you get to know us better as well. All that having been said, the first question is going to go to Monty because we're incredibly chivalrous, as you've heard me say previously. Monty, why have you decided to run for this particular race at this particular time?
Well, my background has been in family court and in criminal defense, and I've been an attorney for 12 years. In looking at the different races, I knew I wanted to run. This cycle would be the last opportunity for another 6 years because all the district courts are at the same time. So I thought long and hard about which race I wanted to run in, and after researching this particular department, hearing complaints from attorneys and others about this particular department, looking at his past success rates in races, he ran 7 times. So I had 7 elections worth of financial figures to go through, as well as the data about past elections, how many percentage of the votes he received in each of the 7 elections. So after running 7 times, he finally won the election, but it wasn't by a large margin. And I thought that it was a opponent that I could take on. And then with the complaints about that particular person, the specific complaints had to do with things that I believe that I could do much better.
Okay. Vince, why have you decided to run for re-election?
I'm on a bench now. I've been on the bench for 4 years. I think I've done an excellent job. The attorneys agree with me that I've done a good job. I have if you go to my webpage, you'll see a long list of people who are on my steering committee. All of those are attorneys, and most of them practice in family law, a great majority, and they have all agreed to be on my steering committee. The Supreme Court agrees I've done an excellent job. I've never been reversed. I have a perfect record on any child custody issue, any child support issue case, any relocation case. In fact, in 4 years, I've only been reversed once, and that's in a termination of parental rights case. And after the Supreme Court sent the case back, the parties both agreed that my decision was correct, and the mother relinquished her parental rights after they came back. I've handled over 3,000, I've handled and decided over 3,800 domestic motions in these 4 years. I've handled over 350 trials. And so I'm in court, when I go on a bench, I'm prepared to address the concerns of the individuals. I read the pleadings, and I help them focus on solutions to their problems and not the problems, and doing what's in the best interest of their child. I treat everyone fairly, with respect, and without bias. I have the good temperament to be a judge, and that's why I'm running for re-election.
And Jason, before you answer, in the 4 years Vince has been on the bench, I don't think I've ever stepped foot in your courtroom. I have no active cases in that department. As such, I'll be participating in the deliberation as well as moderating the interview. If by some freak of nature I end up getting a case and it gets routed to or is already in Vince's department between now and 3 weeks from now, I certainly will not participate in the deliberations, but I'm pretty confident that's not going to happen, just knowing the cases that I take or try to avoid. Not Vince's department in general, but you know what I'm trying to say.
Okay.
So please go ahead.
Okay, a little bit about me. My name is Attorney Jason Stoffel. I've been a family law attorney now for over 10 years. 99% of my cases since day one have been in the area of family law. I get the privilege of practicing family law with my wife, Amanda Roberts. The name of my law firm says it all, Roberts Stoffel Family Law Group. So I pretty much knew I was going to run at the end of last year. I just had to know which department to run in. And as I teased Sandy Pomerantz, I stole her moniker. It was P for Pomerantz, I'm S for Stoffel. That's what I'm going on. That's a catchy phrase, but also there's more to that. I also looked at the RJ poll. Judge Ochoa has a 64%, should this judge be retained. It was 66% in 2011, so it's gone down. Probably the number one reason is just being prepared. There are too many cases that our office, all three attorneys, have appeared in front of Judge Ochoa, and the first thing we get is, what are we here for today? That delays the process, that delays everything when we're in the hallway for an hour trying to figure out why it's taken forever. Is learning as you go. So although things might get filed, if they're not read on time or not read to the point where you understand what's going on, there's a problem. So being prepared is difficult. Consistent with decisions, it shouldn't matter which attorney is in front of you. You shouldn't have to play favorites. Unfortunately, that's what's happening in this department. I know many attorneys that go there, and I've been asked to withdraw my candidacy from other attorneys based on that concept of I get my way in that race, that's why I support the incumbent judge. So that's something that's to be looked at. The other thing that Judge Ochoa mentioned is he said regarding there's no discrimination in this courtroom. I strongly disagree. I have an audio clip here of him saying that he's essentially biased towards men. And what I mean by that, fathers, is he did an interview on KDON back in March and essentially said that men get no overnight visitation with infant children for the first 6 months of a child's life. The next 6 months of a child's life up to a year, one overnight visit. Classic discrimination is prohibited under NRS 125-480, subsection 2. These are just some of the things that have come up along the campaign trail, among others.
Okay. You had mentioned, Jason, I'm sorry. You had mentioned that sometimes individuals seem to get their way in Department X, Y, or Z disproportionately for whatever reasons. Assuming you're confronted with a situation where someone may have donated significantly in a financial respect to your campaign, or may have been a former law partner, or one of your college frat brothers, whatever. How would you handle a situation where you thought that that could somehow affect your ability to sit as a fair and impartial juror, either positively or negatively?
I would strongly adhere to Rule 2.11, which is there's an appearance of impropriety, you have to recuse yourself. And this is something that should be done in every case. I've not had a contributor that's given me enough money that I would be impartial. There's a few folks that have given to Judge Ochoa that I might believe that it might be partial or impartial in certain situations. So I would have to look at that and say this person, at least perhaps for the first year, are not allowed to practice a department as should I be elected. The reason being is because it's a lose-lose situation. If you try to play favorites to some of Judge Ochoa's supporters, then the other side's going to be complaining. If you rule against them, they're going to say you're biased because I gave to the predecessor. So it's something you have to be cognizant of, but I think every judge deep down has the ability to look at every case as impartial as you can. But I've also never been a judge, but I've also never been disqualified like Judge Ochoa was back in June. I have an RJ article on that to prove that.
Monty, how would you handle the appearance of impropriety for financial or friendship reasons? If your partner Susan Bush came in front of you, assuming you're elected, what would transpire immediately?
Well, there's specific rules governing that. If my law partner, former law partner, she can't appear in front of me. If it's a friend, family member, anything like that, close friend, it's not just an appearance of impropriety. There's rules on that, and there's certain people that cannot appear in front of you. So close friends and family members cannot. Someone that you have, not only Ms. Bush, but I have another attorney that I own a building with. That gentleman would not be able to appear in my department because we have financial ties to each other. If it's someone who's donated money, the financial aspect, all of our financials are public record. Anyone who has a case in my department can certainly look online and read who's donated to my campaign. And then if they believe that it's going to affect their case in some way, they can certainly raise it. But if it's somebody that I know, that I have a relationship with, and that wouldn't be public record, where you can look at it on a financial, then it's my obligation to bring it to the party's attention and say to both attorneys, I have a relationship with so-and-so, or a personal friendship. My brother is married to his wife or his sister or something like that. That doesn't make sense, but you know what I mean. So if, obviously I would be cognizant of those issues and bring them up. But the financials are all available online. I don't believe that, the only people that have given any type of significant amount of money to my campaign are people who I would consider close friends, so they already wouldn't be appearing in my courtroom. But other than that, I believe it's my obligation to raise it, and the parties, if they have an issue with it, can certainly bring that up as well.
And Vince, same question.
There is a recusal list, and my son's an attorney. He's already on that list, so he cannot appear in front of me. My daughter-in-law is an attorney, and she's on that list. I have a law building that I'm renting, and the two tenants who are in the building, I've also have put them on a list just so there'll be no appearance of impropriety. And in addition to that, if there's an issue, I raise it to the parties. I belong to the Michigan State Club and the Notre Dame Club, and there's an attorney who appears in front of me is in that club. I let everyone know that we belong to the same club, and they think there is an appearance of impropriety or a possible bias, and I would consider withdrawing myself. Obviously, some attorneys try to make problems, and then just for the purposes of trying to get another attorney. The law in Nevada is that you have a duty to serve. There's nothing easier for a judge to do than to withdraw from a case. If I withdraw from a case, it creates more work for somebody else, less work for me. So it's quite easy. I could do that if people wanted me to, but the Supreme Court law is you have a duty to serve, and that's what I do.
In addition to issues that we have with our friends coming before us or our fellow colleagues coming before us and representing clients, also in family court we have the unique situation of over half of the cases involve strictly pro pers, people representing themselves. What ideas do you have, and I guess we'll start with Vince, we'll start with you first, we haven't done that yet.
Yeah.
What ideas do you have, Vince, to try and make an already difficult and emotional process a little easier for individuals who simply aren't accustomed to the rules and procedures in the family court system?
As my opponent said, sometimes I ask them, why are we here? I don't know what law school he went to, but in my law school, when a professor asked you what's in this case, it didn't mean he didn't know the case. He was trying to see what you knew about the case and explain your situation. So I asked the parties, why are we here? I've read everything. I know why we're here in their prompt, but I want them to focus on solutions. If they just continue to repeat everything they've already said before, it doesn't make progress. If there's children involved, we send them to mediation. We have a family mediation service where people can meet and discuss their situation for a half day up to 3 days. There's also the UNLV Law School. They provide mediation services for small amount of cases. I mean, by small, I mean financially not worth, more than just a house and a car. So they can help them, and they have more time to sit with the parties and do a mediation service. We also, in family court, have created a new service called Pro Bono Attorney Mediation, where we have a list of 20 experienced attorneys who are willing to hear your case for free and provide some mediation service. Through all these services, we can reduce the issues, reduce the tension, get something going as soon as possible, and then if there's still problems, then the district court judge will hear the case. 66% of the individuals that appear before family court do not appear with an attorney. So it's a difficult situation. You want to be fair to both sides, but and you don't want to be their attorney, you don't want to be their advisor, but you need to keep the process moving. I concentrate on everyone being fair, especially with discovery. I tell them that if they don't provide the documents to the other side, I'm not going to review it. If they don't provide a list of witnesses, I am not going to have a trial by ambush. So they get their point, and still, sometimes they come to court on day of trial with new documents and new witnesses. And I depends on the situation. I will normally not hear the witnesses if they have not exchanged the list of names.
Okay. Jason, how would we help out assuming you're elected, how would you help out pro-pers in this difficult time?
This is one of the few times I agree with most of what Judge Ochoa just said. Two of the things he just gave me two shout outs on. The first shout out is the pro bono attorneys that do the settlement, hearing masters or settlement negotiations, mediations. I'm one of those 20. So I went through that process to get on that committee, on that board. The other thing is the UNLV mediation, asset debt distribution. I worked for UNLV as one of the supervisors of that program back in 2010, supervising 3Ls, third-year law students, to assist the process, which is great. I'm also removed, I guess, the past president of the Mediators of Southern Nevada. So I've got more ADR experience than probably anyone at this table right now by doing different mediations, doing different trainings, going out of state doing this. So mediation is always encouraged in any family law dispute. It's right in the rules, right in the statutes, and this is something that should be regularly encouraged. And I believe just Judge Ochoa and Monty Levy, I believe that they come from the same school of thought. There are other ways to get cases done besides litigation, paying attorneys tens of thousands of dollars. So there are ways, so I think all of us at least agree that mediation is the way to go. It should always be explored in any case if possible.
Okay. Monty.
Just to start, I'm not running against Mr. Stoffel or Judge Ochoa, so it feels like But
anyway, you're sitting in between them, which has got to be perfectly comfortable.
It's a little uncomfortable, but
we're all friends here.
Okay, so I've heard Judge Ochoa said it's 66% of people. I know it's over 60%. I don't know the exact amount of people, but there are a large amount of people that are unrepresented in family court. They come in, they can't afford an attorney. We expect them as judges to know the rules, but they're not attorneys, so we have to be patient. And that's the number one thing that I think any of the family court judges need to learn is a little bit of patience with people, because these are individuals, it's a highly emotional time in their life. They're coming into family court and they're fighting for what's most important to them, whether it's their children or their property that they've worked their entire lives to acquire. They're coming in and they just want to be heard. And that's the biggest thing that we as judges can do to help people, is just to listen. Because and I'll speak to the department that I'm running in, the judge is short-tempered and doesn't have patience with people. In fact, oftentimes doesn't even have hearings and will rule strictly on the pleadings. Now, if you think about it, a lot of times in a divorce case, You've got one party that has control of all the assets, has taken the bank accounts, taken everything, and the other party is left with nothing. So one party is able to hire a high-priced attorney and the other person is representing themselves. Now, possibly English isn't their first language. Possibly they're not literate and they can't write a cohesive brief on what they're supposed to be talking about. So you have an attorney on one side writing a motion and someone who may or not be able to formulate in opposition to that motion. And the worst thing that you can do in that case is to just read what was written and make a decision based on that and not have a hearing and just issue a minute order. Because these people deserve to be heard. And you can't just rule on the pleadings, especially when one person is represented by an attorney and one isn't. And that's oftentimes what occurs. And a lot of times in family court, when people leave, they're not happy, and it's not because they won or they lost, it's because they don't feel like anybody listened to their story, and all they want to do is be heard. So I think that's the biggest thing. The other thing is I think that if there is a potential language barrier, if English is not their first language, or even if they are conversational in English, but it appears as though they may not understand all the legalese, I think that we have a duty to provide an interpreter for these people that come into court and may or may not be able to fully comprehend everything that's going on. And only until recently, interpreters weren't provided. If you needed a court interpreter for family court, you had to arrange for that interpreter to be there. You still have to arrange for it yourself ahead of time, and then you had to pay for it yourself. Now, these are people that can't afford attorneys, they can't afford the filing fees, English isn't their first language, and we want them to pay for their own interpreters. And I think that it's discrimination and it's unconstitutional to discriminate based on country of origin, and we shouldn't do that. We need to make sure that the access to the courts is equal to everyone who's in our state.
Do they have the interpreters now?
Well, you still have to arrange for it, and sometimes the interpreters want to be paid by the party, but it's
So
supposed
there's
to.
no sliding scale interpreter?
I'm not sure how the interpreter's office handles that. That would be taken up with the interpreter's office, but I think that we have a duty to provide the interpreters for the litigants.
I want to say the interpreters actually can call their own shots on that. I think they can set their own prices and effectively create their own sliding scale is my understanding, but I'm not positive of all the changes.
Right, but if you're accused of a crime,
I'm saying even in
Right.
civil arenas.
Right.
It's my understanding.
I
but,
think that we should provide them in all courts for all persons.
We have referenced earlier, not only throughout the day today, but also in this interview, we referenced the much vaunted RJ surveys and the various numbers attached to them. And I'll start with Monty, and then we'll rotate back in the opposite direction. Monty, what ideas do you have to improve the RJ's biennial survey to make things either a more accurate representation of how the judges are performing on the bench, or perhaps to make things more readily digestible for civilians so they can use the information contained in that survey and apply it to voting situations such as this?
Well, my feelings on the RJ survey, they're mixed. I think the survey does a really good job in the criminal courts and the civil courts of telling people how these judges are doing. But what's different about family court is that, again, there's over 60% of our litigants are not represented by attorneys. Only attorneys that are licensed to practice and that practice here in Cook County are asked to fill out these surveys. But you've got over 60% of the people that appear in court without attorneys that aren't asked to fill out these surveys. So what do the numbers mean? They don't mean that much in family court because they're only less than half of the people that are appearing in front of the judges are filling out those surveys. So what we need to do is when you have, it's all public record, who's got cases in what departments, and if they're pro per, those individuals should be asked to rate their experience in front of that judge. Did the judge listen to you? Were they friendly? Were they fair? Did they take into consideration what was put in the papers? Did they take into consideration what you brought to the table? Did they listen to your witnesses? Things of that nature. So I think that not only attorneys should be given the survey, but individuals that have cases in that department that are not represented by attorneys. And I think that's a big deal in family court more so than in the civil and criminal courts, because generally speaking, people have attorneys when it comes to those disputes in civil and criminal courts.
Jason.
I agree to some degree. I think that giving pro pers or those that do not have attorneys an opportunity to do this, I think it gets more heated and more biased because it's their case. So if the judge perhaps ruled against them, they're going to be more spiteful, more venomous is the word I'll use. I think it's it opens up a can of worms. But the other thing I know, it's also been said that attorneys don't get the polls, or they don't get the opportunity to participate. So I know that's how do you work out those bugs, I suppose. How do you see to it that every attorney in Clark County gets an opportunity? And that's one of the things that I think the Clark County Bar Association, the local bar, could do a better job of that. I know I'm one of the 13 members on the board of directors with that organization. I asked them if they wanted to get involved. They said that's an RJ thing, we're not getting involved with that. But I think just the awareness of saying the importance of doing it, because some judges will cite that there's only perhaps 100 attorneys that respond to these polls. And most inappropriately, I suppose, are attorneys that rate family court judges that they've never been in front of. That probably happens because, if I practice every area of law, civil, criminal, and family, I would be doing the survey for over an hour. But luckily for me, of the 20 family court judges, I will rate accordingly, and a handful of the civil ones that I've ever had a case with, which has been very rare. So I think just being aware that this poll exists and using it for what it's intended to do, to inform the public, because by and large, we see all these pretty signs on the side of the road. We don't know much about judges. We really don't. So I think having a number is the way to go. And I think just, I don't know why they don't do it every year, because I think that should show modern trends. Because some judges, newer judges, perhaps they start off on the low end and go up. But my opponent went from 66 to 64, so he's going the wrong way. Some of the judges that are the most popular ones and probably the best judges, just by that poll, are in the 80s and 90s. So I think anything above 75 is acceptable, below 75 unacceptable.
Okay. And Vince?
My rating was 64%, and when I went to interview with the RJ, I said, there's thousands of attorneys in Clark County, and there's only 100 who answered in my survey. So my survey was only of 100 attorneys, and they rated me at 64%. And the RJ said we send them to their last known address, and you know how attorneys move and change firms, so that could be part of the problem. Also, if you look at the internals of my survey, when they asked, is he biased against women, 90% said no. Is he biased against men, 90% said no. Is he biased based upon the attorney, 90% said no. Is he biased based upon religion, 90% said no. So that's what I'm supposed to be, is non-biased, Obviously, out of the 100 attorneys, 90% said I was not biased in any of those areas, and they gave me a rating of 64%. Obviously, when you go to family court, I try to make sure that we do everything in the best interest of the children and be fair to both sides. But obviously, sometimes one side thinks they lost, sometimes both sides think they lost because they didn't get what they want. But I try to be fair to both sides, give them a fair time to listen to their cases. In my family situation, I have 4 children, 2 boys and 2 girls. So I don't know what bias means against being against one side or the other. And so I have no bias one way or the other. He says I'm biased against men. Equal Rights for Fathers is endorsing me, so they do nothing but men's cases, and they don't see it that way. They endorse me.